Hello, thank you for joining our webinar, What Employers Need to Know About Wisconsin's Concealed Carry Law. The presentation will be about a half hour, after which Rob will answer as many questions as he can. A few logistical items I'd like to point out before we get started. The slide presentation will advance automatically in sync with the live presentation. If the full slide does not appear on your screen, go to the top of your screen, click View, then Shared Application Size, then check Fit to Whiteboard. Since there is such a large number of participants in our audience today, you will not be able to verbally ask questions. However, we ask that you please type your questions using the Send Note button at the top of the screen. Use the drop-down box and send your note to Reinhardt, Borner, Van Duren. We will answer as many questions as possible during our Q&A session at the end of the webinar. And now to introduce today's speaker. Rob Scholl is a shareholder in the firm's labor and employment practice. He has been advising and defending employers in the full range of labor and employment law matters for more than 29 years. He recently finished a 15-year term as chair of the firm's labor department. Rob is a well-known speaker on employment topics. He is also co-author of Wisconsin Employment Law and Hiring and Firing in Wisconsin, both published by the State Bar of Wisconsin. Rob graduated from the University of Chicago Law School. He has a master's degree in industrial relations from the University of Warwick Business School in England, and he is a Phi Beta Kappa graduate of Dartmouth College. And now, let's get started with our webinar. Rob?
Thank you, Nancy, for that introduction, and thank all of you for participating in today's webinar. We're truly delighted by the number of you that have signed up. I've given hundreds of speeches over my 29, 30 years of practice, but I have to admit this is the first webinar I've ever done. I'm sitting here facing mostly an empty room. This was a speech I would think it wasn't a very successful one, but I know there are a lot of you out there. But it's a little bit like a scene from The King's Speech for those of you who have seen the movie. I'm just here in the room with a microphone in front of me. Anyway, without further ado, let's get started. The Personal Protection Act was signed by Governor Walker on July 8th of this year, and it goes into effect on November 1st. And in broad strokes, it permits licensed individuals to carry concealed weapons throughout Wisconsin, subject only to a few exceptions, and we'll talk about those exceptions today. One of the first questions, of course, is what's a concealed weapon that somebody can carry? And as you can see in the slide, we've specified what those are. Handguns, knives, but not switchblade knives, billy clubs, and electric weapons. Those are the things that you will be licensed to carry starting November 1st. The definition of handgun specifically excludes machine guns, sawed-off shotguns, sawed-off rifles, and the like. So you don't have to permit even licensed individuals to bring a machine gun into your place of work. One thing that's important to note at the outset is that this new concealed carry law does not in any way overturn or supersede Wisconsin's open carry law. And so it doesn't limit an individual's right to carry a weapon that is not concealed. Even with open carry weapons, there are a number of places where it's illegal to openly carry an unconcealed weapon. And again, there are a number of weapons that cannot be carried even openly. Similarly, this new law does not impact existing Wisconsin laws on who is legally allowed to own a weapon. Those laws haven't changed. Similarly, the laws on what type of weapon an individual may own, those laws in Wisconsin have not changed. The Wisconsin Department of Justice, which I'll talk about as the DOJ in shorthand from here on out, has the task of creating some regulations to implement this new law. As I mentioned a minute ago, the law goes into effect on November 1st. The regulations, however, are not out. And we've contacted the Department of Justice to say, when can we expect those? Because regulations, as you know, typically fill in a lot of the detail and answer some unanswered questions as to exactly how this law will be implemented. The only thing the Department of Justice is willing to say at this point is that it will commit to publishing those rules by November 1st, which of course is the effective date. So stay tuned as to when those come out. With the passage of this law in Wisconsin, Illinois is now the only state that doesn't allow some form of concealed carry. Who can carry concealed weapons? Well, the answer to that is simple. Any licensed Wisconsin resident who's age 21 or older. The DOJ has to design the license by September 1, 2011, so that deadline's coming up. The application process, however, doesn't begin until November 1st, 2011. In other words, there's no pre-effective date application process being recognized by the DOJ. The DOJ will issue licenses subject to a background check and completion of certain training requirements. The background check simply is aimed at determining whether an applicant is prohibited from carrying a firearm. The Department of Justice will conduct that background check. That's not a burden that's going to be placed on employers. And it will consist of a criminal history record search, both Wisconsin and national. The Department of Justice will design the application form by September 1. That form will contain a statement on self-defense and defense of others. In other words, it will summarize what the Wisconsin law is in that regard. And in filling out the application, an applicant will say, yes, I've read and understand Wisconsin law on when it's permissible to use a firearm in self-defense or for defense of others. And the DOJ will also charge a license fee and a background check fee in connection with the application process. In terms of the training requirements, the law does specify, gives some detail about what those training requirements will be, but really I think we're going to wait till the regulations to find the full detail on what's required. There are some details given so far. It's contemplated, for example, that an applicant will have to provide a document showing that he completed some sort of training, maybe a hunter education program offered by the DNR, for example, or a firearms safety or training course, or a document that, you know, I was in the military or I was in law enforcement, and in that context, I was trained on the safe use of firearms. The Department of Justice will certify law enforcement instructors and maintain a list of them, but it will not certify civilian instructors and will not maintain a list of civilian instructors that are qualified to give this training. The license has to be renewed every 5 years. And the final bullet point on this slide, it's not clear yet to what extent other states' concealed carry licenses will be honored in Wisconsin. One thing is clear from the statute, and that is that if you are a Wisconsin resident and you have an out-of-state license, currently that's not going to be valid in Wisconsin. In other words, that won't work. You're going to have to go through the application process here in Wisconsin. The DOJ will, however, establish a list of states with comparable background checks. That seems to be the focus. The DOJ wants to make sure that the background checks that other states are doing are as thorough as the background check here in Wisconsin. And once it establishes that list of states, then it's thought that persons licensed in such states may also carry concealed weapons in Wisconsin. And indeed, the DOJ, per the statute, can enter into reciprocity agreements with other states concerning the authorization to carry concealed weapons here in Wisconsin, and vice versa. In terms of who can get a license, it's important to note that Wisconsin is a shall issue state, and that simply means that the licensing process is not discretionary. There are some states where somebody can fill out the application, but some government official, a sheriff or a police captain or the like, is given some discretion about whether or not to issue the license. That's not the case here in Wisconsin. We are a shall issue state, and the DOJ must issue licenses to each person who meets Wisconsin's statutory and regulatory requirements to get a license. The statute specifically says that the DOJ cannot impose conditions or requirements not expressly provided for in the law. The law also states that the DOJ has to issue a license or deny an application within 21 days, so that's a fairly short turnaround time. There is a little caveat to that statement I just made, and that is during the ramp-up period, and that's from November 1st through December 1st, the DOJ is going to have 45 days in which to either issue a license or to deny the application. But after that ramp-up period, then it will have 21 days to make a decision. If you are applying for a license and you are denied by the DOJ, you have two appeal options. One is the DOJ is going to set up a review process whereby if it turns you down initially, you can go back to the DOJ and say, can you please reconsider? There's another appeal option, and that is you can march into circuit court and file a complaint over the DOJ's refusal to issue you a license. The grounds for denying a concealed carry license are those on this slide 7. You're not a state resident, you're under age 21, you haven't complied with the training requirements, or that you are prohibited from carrying a gun by court order or by federal or state law. And there are a lot of examples of this. I've just given you a few in the PowerPoint slide. One is, for example, if you're a convicted felon, you're not going to qualify for a license. Similarly, if you've been judged mentally incompetent and the like, you're not going to qualify for a license. These next few slides, I'm going to talk about what the general rules are under this concealed carry law. And first of all, the law creates a right for a licensed individual to carry concealed weapons onto property unless there's a specific prohibition by the owner or occupant of the property. But even then, even when there's a specific prohibition, that prohibition does not apply to weapons in vehicles driven or parked in parking lots or parking facilities on that property. And this motor vehicle exception you'll see throughout the discussion today. So that, again, is kind of a general principle that underlies this law. Persons who carry concealed weapons must also carry two things with them at all times. One is the concealed carry license that's going to be issued by the DOJ, and the other is a photo ID. And generally speaking, they always have to have those two documents on them. The only exception is if they're in property that they own, lease, or otherwise legally occupy, they can have the concealed weapon there and not have these two documents with them. A photo ID is simply going to be a driver's license, or for those who don't have driver's licenses, Wisconsin identity card. That's the kind of thing we're talking about. There are some locations where concealed carry is never allowed, and on this PowerPoint slide number 9, I've given you a list of most of those locations. And they're the kinds of things that you would expect: schools, police and state patrol stations, sheriff's offices, prisons, jails, courthouses, secured portions of mental health treatment facilities, in-session municipal courtrooms. I guess what that means is if the municipal court is not in session, you're free to take your pistol in there and carry it around. And then airports, but only beyond security checkpoints. And again, I think this is interesting. Apparently you can walk into an airport with your concealed carry weapon. You just can't go through security with it and beyond. I don't know, I guess one could argue that maybe they should be prohibited from the front door onwards, but that's not the law. Again, this parking exception comes in. Even in these places that are at the top of this slide, the prohibition does not apply to weapons in your own personal vehicles within the parking lot or the parking facilities at these locales. There seems to be a notion here that when a gun is in the car, it's somehow safer than when you're carrying it on your person. Violators of this portion of the law are subject to a $500 fine, up to 30 days imprisonment, or both. And one other important kind of overarching point to keep in mind is that this Wisconsin law does not trump or supersede federal law. So even though you're a licensed concealed carry person under Wisconsin law, that does not necessarily allow you to possess or carry firearms in United States government buildings or on U.S. government land. Federal law is going to apply to your right to carry a firearm on federal property. Who can ban concealed carry? The law gives that right to property owners and legal occupants to either ban or conversely to permit the possession of certain weapons on their premises. If they choose to ban and notify an individual, in other words, somebody who's received notice of that ban, fails to abide by that ban, that person's guilty of trespass under the Wisconsin criminal laws governing trespass. That person's guilty of trespass and subject to a Class B forfeiture up to $1,000. The notices that there's a ban in place generally should be via postage sign, and we're going to talk about what signs are required a little later on. This slide talks about where may concealed carry be banned. And we first talk about non-residential buildings. The owner or legal occupant may prohibit concealed carry on any part of a non-residential building, on the grounds, or on the land. There are a couple of exceptions to that, and that's one, I think they're listed here in the slide. First thing I should say, for a multi-tenant building, the tenants themselves have the option to ban weapons with regard to their own space in that multi-tenant non-residential building. So it's the lessee's or the tenant's call. And then there's the usual exception for parking lots. Again, even though you ban concealed carry in a non-residential building, that ban cannot extend to a parking lot or a parking facility in the building or on the grounds or on the land. In looking over the list of people who have signed up for today's webinar, I see we have many employers and companies in the healthcare industry, and that's why I included this bullet point to make clear that as far as the state of Wisconsin is concerned, nursing homes, hospice facilities, residential care apartment complexes, community-based residential facilities, adult family homes. Under the Wisconsin law, these are considered non-residential buildings, which might fly against logic a little bit, but that's how they're categorized, and it's important for those of you in the industry to understand that. Turning then to residential buildings, again, the owner or the lessee or legal occupant of an apartment or a condo may prohibit concealed weapons. In residence, the definition does not include common areas of the building where the residence is located or any common areas on the land or grounds. In other words, for multi-tenant buildings, the tenants have the option to ban weapons inside their own apartments or condominiums. The landlord, or the owner, I should say, of a multi-family residential building has the ability to prohibit concealed carry in common areas and on the grounds. But this prohibition applies only to visitors. If you have a condo owner, for example, in a residential building, and that condo owner is a licensed concealed carry individual, you have to, as the building owner, allow that person ingress and egress to the condominium, and you can't prohibit that person from carrying the concealed weapon as they go in and out of their condominium through common areas and through grounds. And once again, there's that exception for the part of the grounds or the part of the multifamily residential building that's used for parking. And finally, to close out the single-family residence or the residential buildings portion of this slide, I want to talk about single-family residences. The owner or the lessee of a single-family residence has the right to prohibit concealed carry, and that includes the land on which the residence sits. This slide talks about special events. The organizers of a special event may prohibit concealed carry. Well, what's a special event? Well, that's an event that lasts no more than 3 weeks in duration, and it requires admission, or the entrances are locked. You just can't walk on the grounds willy-nilly. Some have called this, the Summer Fest or the State Fair clause in this law. And again, you have that same general exception for parking facilities, parking lots, etc. All right, here's the heart of really what I wanted to talk about today, and that is concealed carry's effect on employers. First of all, I should note that it affects all employers regardless of size. You don't have to have a certain minimum number of employees to trigger coverage under this law, and that's different, as all of you know, from a lot of federal and state laws that may apply only to employers of a certain size in terms of number of employees that they employ. This one applies to everybody. Employers have the right under the law to prohibit licensed employees from carrying weapons, concealed or otherwise, in the course of their employment. Now, there's an important exception to this that we're going to mention in a minute, but the general rule is employers can tell even their licensed employees, you can't carry weapons in the course of your employment. And that includes not only the business owner's own facility, but any off-site work site. So, for example, if you have salespersons that call on your customers, you can prohibit them from carrying their weapons into the customer's place of business as well. Employers have the right to prohibit weapons in employer-owned vehicles, and I put the emphasis on employer-owned vehicles purposely, as you'll see in a minute. An employer cannot bar an individual from employment because he or she is a concealed carry licensee. So, and this is a very important point, you can't screen employees or applicants for employment, I should say, based on whether they're a concealed carry licensee. The Department of Justice will maintain a list of who has such licenses, but that's not going to be a public list, and you're not going to be able as an employer to call DOJ and say, I've got an applicant here, tell me whether or not he or she is on your list. And in fact, the only people that are going to have a right to see that list are law enforcement agencies, and even they can only see whether a particular individual is on that list in very limited circumstances. So while the DOJ is going to maintain this list, it's not a public record that the DOJ has to disclose to the public. Here's an important point at the bottom of the slide on page 14. An employer cannot prohibit licensed employees from carrying or storing concealed weapons or ammunition in their own motor vehicles, even if those vehicles are used in the course of employment. So I told you a few minutes ago that the general rule is that as an employer you can prohibit your employees from carrying weapons in the course of employment, but here's an exception to that. They do have the right to carry or store weapons during the course of employment if they're using their own car or truck or van or what have you on company business. And then again, there's that same general exception for cars driven or parked on your property. One thing that's worth noting in the statute at least, and maybe this will be addressed in the regulations, we'll see, but one thing worth noting is that the Wisconsin statute does not specifically address how employees may store weapons in their own vehicles. And so depending on what the regulations say, you as an employer may be able to impose some restrictions. In other words, you don't prohibit them from storing or carrying weapons in their own vehicles, but you may be able to implement a policy that says you have to keep them out of plain view. You have to keep them in your trunk, for example, or in a locked glove compartment. You have to keep your car locked so people won't have easy access to your weapons, etc. This next slide applies not only to employers but also to third parties. And that is, you can prohibit third parties, your customers, your vendors, from carrying a firearm into your buildings or onto your grounds or land. Once again, this prohibition cannot extend to a firearm in a vehicle driven to or parked in any portion of your building, grounds, or lands that are used as a parking facility. So that same general exception appears here as well. One of the most interesting and yet at the same time confusing portions of this law has to deal with immunity. There's an immunity provision plopped in towards the very end of Section 175.60. And it says as follows, that persons and or employers that do not prohibit concealed carry are immune from liability arising from that policy decision. And that's something that each of you is going to have to consider. It's not clear at all how far that immunity will extend. Remember, it says there's immunity from the decision not to prohibit. The scope of that immunity, however, I think we're going to have to wait for regulations and more likely probably for case law decisions. For example, I don't think that it's going to relieve an employer of workers' comp liability. Let's say as an employer you permit concealed carry and one employee comes in with a concealed gun and shoots another employee in your facility. I have to believe there's still going to be workers' comp liability for that, and I don't think that this immunity is going to shield you from your workers' comp liability, but we'll see. There's also some thought that even though you may not be liable for your decision not to prohibit concealed weapons, you won't be liable based on that decision. You may still be liable for other things caused by your own negligence in other contexts. And here's an example I came up with. Let's say you're an employer and you don't ban concealed carry in your workplace. A customer calls you one day and says, you know, the salesperson that you've sent over to see us, he's terrible, he's awful, he's rude, he's disrespectful, don't want to ever see him darken our door again. And of course that naturally causes you some concern, so you call in the salesperson and you tell him about the customer complaint and you discipline him. Maybe you give him a demotion, for example. During that disciplinary meeting, the salesperson gets pretty hot under the collar and says, you know, I'm really angry at that customer and those are not fair criticisms. Next time I see that customer, I'm going to shoot him. And you do nothing in reaction to that threat being made. The next time the customer comes to your facility, your salesperson sees him, pulls out his concealed weapon. Do you have full immunity in that scenario? Well, you wouldn't be liable because of your decision not to ban weapons, but you might be liable on other grounds. For example, maybe it's negligent retention, which is a tort that's been recognized in Wisconsin for the last 10 or 15 years. Maybe it's negligent retention for you to have kept that employee after he made that kind of threat and to do nothing to prevent your salesperson from carrying out that threat. So there is this immunity. I think we're going to have to see what the scope of it is. I'm not sure it's going to make you immune from any and all claims, such as workers' comp, negligent retention, and the like. For those who, on the other hand, prohibit concealed carry, the question arises, are you somehow assuming a heightened duty to protect? In other words, if you prohibit concealed weapons in your building, do you at the same time then need to do something to make sure that they're not being brought into your building in a concealed way? Do you need to install metal detectors? Do you need to frisk visitors and employees as they come through the door in the morning? Do you need to do that because that's really the only effective way you can enforce your ban of concealed carry weapons? And another example, let's say you do prohibit concealed carry. You have a customer that ignores that prohibition. The customer comes into your building and gets into an argument with the vendor. And things grow so heated that the customer pulls out a weapon and shoots the vendor. By banning concealed carry, have you somehow assumed a duty to protect that vendor? And if so, were you negligent in not enforcing the ban vis-a-vis the customer? There's not a lot of case law out there that gives us guidance. Again, we're going to have to see what the regulations say, and again, I think more importantly, what the case law is. Changing those facts slightly, let's say the vendor, this is the person that got shot, is also licensed to carry a concealed weapon. And the vendor honors your ban. He leaves his weapon in his car before he comes into your building. Again, your customer shoots the vendor after they get into a heated argument, and the customer shoots the vendor twice. And the vendor then says to you after he recovers, you know, if you hadn't prohibited me from carrying my gun into your building, I would have been able to defend myself. And I wouldn't have been injured so seriously, and that customer sure would not have been able to shoot me a second time, and that's the second shot that really did all the damage. You didn't allow me to adequately protect myself by imposing this ban. Now, are you liable to the vendor under those circumstances? It's not clear. Was it foreseeable that this would happen? You know, those are the kinds of legal issues that will be debated and disputed, I think, in the courts. Again, as I talked about, nothing in this law provides that the Wisconsin law trumps federal law. Similarly, this immunity provision of the law will not apply to federal law. And as I think you all know out there, OSHA has a general duty clause that says you need to provide to your employees a place of employment that's safe. And if you decide not to prohibit concealed carry in your workplace, are you fulfilling that OSHA general duty clause? That's a good question. Steps to be taken by an employer or business wishing to ban weapons. Posting, and we're first going to deal with posting a building. If you want to prohibit individuals from carrying firearms into your building, you have to post signs that are at least 5 inches by 7 inches. They have to be posted in prominent places near all entrances and spots where individuals entering the building can reasonably be expected to see the sign. So you're not going to be able to put such a sign behind the receptionist's desk. That's not going to do it. Right now, there's no specific language that's required by the law. You simply have to state the prohibition or limitation. It may be that the regulations will give us some more detail. Maybe the regulations will specify the language that you're supposed to use, or specify print size, or specify the color of the poster, but so far we don't have any of those details. Lower part of slide 17, in terms of posting your grounds, you have to post signs in a prominent place near all probable access points to the grounds. Again, in spots where individuals entering your grounds or land can reasonably be expected to see the signs. Again, we don't have any specific language about what's got to be said in those signs used to post your grounds either. This next slide deals with posting land. If you want to prohibit individuals from carrying firearms onto large tracts of land, an owner must post signs that are larger, 11 inches by 11 inches, and those have to be posted in 2 conspicuous places for every 40 acres to be protected. There's a little more detail in terms of what the content has to be of these land signs. says you have to provide an appropriate notice, and again, it doesn't specify what that is, but then it doesn't make clear that the name of the person putting out the poster has to be indicated on the notice. And if you're the owner, you've got to write your name followed by owner. If you're the occupant, you have to type or print your name followed by the word occupant. So a little more detail there. All right, recommended employer action in light of this new law. The first bullet point is really the key decision you're going to have to make as an employer. Are you going to ban or are you not going to ban concealed carry? This is the major policy choice that faces you as an employer. And you're going to have to weigh the value of that statutory immunity that I talked about a few minutes ago as you make this choice. And remember that the immunity granted is immunity from any liability arising from the decision not to ban. I don't think it's a blanket immunity, but again, we'll have to see how the courts interpret the scope of that immunity. My suspicion, though, is it's not going to be total immunity. If you do ban, then you're going to have to consider whether you have the heightened duty of care to employees and visitors that I talked about a few minutes ago. And again, we're going to have to see how the courts rule in terms of whether you have a heightened duty of care because you choose to ban concealed weapons. You should certainly start immediately, I guess, to review your employment policies to identify any necessary revisions. Many of the policies that I've worked on in this context over the years with employers where we talk about weapons, those policies I know have prohibited weapons not only in the building but also in the parking lots. And it's clear that if you have a broad policy, a workplace violence policy like that that prohibits weapons anywhere on your property or premises, you're going to need to revise that policy. As I talked about a few minutes ago, you should consider adopting a policy that contains some reasonable restrictions on how weapons are stored and how ammunition is stored in employees' personal vehicles in your parking lot or in your parking facility. Again, I think pending the regulations, you may be able to say you have to keep your car locked, you have to keep your weapons and ammunition on site. So that may be another part of a policy that you adopt in reaction to this new law. I think right now there's nothing in the statute that prohibits you telling your salespeople, for example, that even if they're using their personal vehicles to get to your customers, they can't bring in a concealed weapon into the customer's place of business. One little issue that's arisen is what if you have a company car, because I told you earlier that generally you can prohibit concealed carry in company-owned vehicles, but what if you have a company car that your employee has 24/7 and they're specifically allowed to use that company car for personal business? Is there an issue then about whether that's a company car or a personal vehicle? It's a good question. I don't have the answer to that, and we'll have to see. If you do opt to prohibit firearms in your buildings or on your grounds, you might have to make sure you have the posters posted that we talked about a little bit ago. Another thing you should think about is supervisory training, as you would always give supervisors training when there are new laws passed that impact employment. You have to tell them that they can't screen applicants by determining whether an applicant has a concealed carry license. Nothing in the statute specifically prohibits you from asking an applicant, but I think that's going down a dangerous path. And you should only ask that if you have a compelling reason. And then, of course, just as you ask about any protected characteristic, once you do that, how you use that information is going to be very critical. But I think you should have a policy in place when you train your supervisors. Are you going to allow them under any circumstances to ask somebody whether they have a concealed carry license? And again, tell supervisors that they can't prohibit carrying or storing concealed weapons in private vehicles. You should review your pre-employment background check procedures and your security measures to address what's perhaps an increased risk of violence given the potential presence of concealed weapons on your company property. As you look at your background check procedures. Remember, you don't want to do anything that would run afoul of Wisconsin's prohibition against arrest and conviction record discrimination. I would look again at your security measures. If you want to permit concealed carry weapons, I think you should still have a violence in the workplace policy that should be updated in light of this new law. And what is your plan in the event a person starts brandishing a firearm on your premises? I think you should have a plan in place to deal with that. If you have a policy, of course, you'll want to enforce it. Again, you want to weigh the pros and cons of banning third parties, such as customers, visitors, or vendors from concealed carry. If you're a gun store and your business is selling handguns, that's one business consideration that may make you not want to prohibit. I think you have to look at your own circumstances and decide what makes sense to you and for you vis-a-vis third parties, customers, visitors, and vendors, etc. All right, we'll take questions now. All right, the first question is, what liability might attach to an employer who does not allow concealed carry by either its employees or third-party visitors, but then a non-employee visitor shoots and harms an employee who lacks the means to defend themselves? This goes back to the scenario I talked about during my speech. I don't think it's clear whether, as an employer that prohibits concealed carry, whether you have this heightened duty of care. In this instance, the person that's getting shot is an employee, and the employee apparently has a concealed carry weapon, but it's not in the workplace per your rule. I think workers' compensation in this instance would probably be the injured employee's exclusive remedy. Some question about whether there are other types of liability that might be out there, but I would think, although it's not specifically spelled out in the statute, that we're probably talking about an exclusive workers' comp remedy. Next question is, can an employer find out if any of its employees has the right to carry a concealed weapon? The answer to that is no and maybe. You certainly can't contact the Department of Justice and say, can you tell us whether our employee John Doe is on your list of licensed concealed carriers? Again, that's not a public record that the Department of Justice is going to give to you, and they're not going to answer your inquiry. Talked a little bit about whether you have the right to ask that directly of the employee, and again, I said I think you got to be really careful before you go down that path. I'm not sure that's a great idea. Question, how does the Wisconsin concealed carry law interact with federal laws such as OSHA General Duty Clause? Again, I think I've covered this. It doesn't preempt. The Wisconsin law doesn't preempt federal laws, and I don't think there's any basis to think that it's going to preempt OSHA's General Duty Clause. So if you're going to permit concealed carry, I think you're also going to have to keep an eye on what your obligations are as an employer under OSHA's General Duty Clause. Question, can a landlord prohibit tenants in a non-residential building from carrying in the hallways and thus effectively prohibit them from carrying in the space the tenant occupies? No. The landlord can certainly prohibit, or the owner, the carry of concealed weapons in common areas, but your tenant has a right of ingress and egress to their own space that they legally occupy, and that means in terms of your right as an owner or landlord to prohibit concealed carry in the common areas, you have to allow the tenant to get in and out of their leased space with concealed carry. Okay, let me see if I can understand this question. If we post a ban on concealed carry and someone drives a gun into our parking lot in their car and parks their car, do they have to keep the gun in their car, and are they prohibited from taking it out of the car to show someone? I think the answer to that is yes. It's not clearly spelled out in the statute. Again, we may get some more detail in the regulations. Again, what the law says is they have the right to carry or store the concealed weapon in their vehicle, and I don't think that includes taking it outside of their vehicle and carrying it around and showing it to folks. That may be something that you'll want to address, at least as far as your employees are concerned, in your employment policies. Take maybe just one more question so we can keep on our time schedule. The question is, I realize the regulation release date is to be determined, but have you heard anything about when the regulations might be released? The only thing I've heard is when we tried to press them about when we might expect the regulations, they said, we're not going to give you a date. We'll just tell you that they'll be out before the law goes into effect. So, is the link on the next slide? Okay. Well, one thing I wanted to mention to you just as we close up here, thank you for all your questions, by the way. I wanted to mention to you that the Department of Justice has issued a 49-page question and answer document that I read through carefully, I guess 2 or 3 times getting ready for today's seminar. If you want to shoot me an email, I think I can send you a link so you can get to that and print that out, and if you're lacking sleep some nights, start reading that, and I'm sure you'll go right to sleep. So I'm glad to give that link. Also wanted to mention that we have developed here at Reinhardt a model safe workplace policy. We'd be delighted to provide that to you for a reasonable charge. So simply contact your favorite Reinhardt labor and employment attorney, and we can put you in touch with that model policy. And of course, we'll be more than happy to work with you on revisions to your workplace policies, your handbook policies in this regard. And then finally, the last thing I'll say is once the regulations are published by the Department of Justice, I imagine we'll send out another e-alert about concealed carry. So if you're interested in getting that, just shoot me an email. I'd be glad to make sure that you get that post-regulation client alert. And we may do another webinar too, depending on how much clarification, I guess, the regulations have given us. So thanks very much for listening to me today. I'm going to turn the program back to Nancy.
Thank you all for attending. We have recorded the webinar today, and by next week we will have it posted on the event page of our website. We will also send you an email that will have a link to the recorded webinar. Thanks again for joining, and if you have any questions also, you can feel free to send them to me as well, and have a great day.